A unanimous blow against the Biden administration. The Supreme Court comes out, rules against their administration in an agency lawsuit dispute. Justice Kagan is the lead author of this 9-0 opinion. There are some concurring opinions and concurring opinions in judgment, but we don't often see this where there is such unanimity. Here, a Supreme Court ruling on April 14th made it easier to challenge the reach of two federal agencies, the FTC and the SEC. Red tape cutting decision that is a defeat for the Biden administration. The Supreme Court took steps to rein in so-called administrative state bureaucracy nonsense and reaffirm the separation of powers. Litigants challenging the agencies argued they should be able to contest the way the tribunals are constituted in federal courts without having to go through a long, lengthy administrative proceeding. The Biden administration argued the challengers may only proceed after losing in agency proceedings. So what is the proper recourse? You have a complaint. Do you have to jump through all of these hoops, or can you bypass that and go a different way to get your remedy? Now, this is coming out of Scottsdale, Arizona. Axon makes body cameras that the police use. Axon purchased an LLC. FTC sent Axon a letter about antitrust concerns, and the FTC said, you didn't satisfy us. You didn't do the due diligence that we require. This case originally came up from the Ninth Circuit. Argument was back last year, November 7th. The opinion came out 9-0 by Judge Kagan, reversing and remanding the Ninth Circuit 9-0. An opinion came out from Justice Kagan, Justice Thomas concurring in the opinion, Justice Gorsuch concurring in the judgment. So saying I like the outcome, I might have a different reason as to why I think this outcome is the right outcome, but I agree with the judgment. I agree with the outcome. 9-0. We don't see that often these days. So let's take a look at the opinion. Axon Enterprise versus the FTC, coming out of the Supreme Court of the United States. They say that Michelle Cochran and Axon initiated complaints against the FTC and the SEC, challenging the constitutionality of agency proceedings against them. They opened an inquiry against their companies. They say, you can't do that. The court says, when, as in the enforcement actions against Cochran and Axon, a commission elects to institute administrative proceedings to address these violations, it typically delegates the initial adjudication to an ALJ, an administrative law judge, with the authority to resolve motions, hold hearings, and issue decisions. And this is something that you often see in MVD or DMV proceedings. DMVs are licensing agencies. You know, you have a privilege to get a license. A license is a privilege they can give you. You're not entitled to have a license. And if you have a license and they want to take that license away, if they want to challenge your capability to do something in the public space, in this case, drive. In this case, it would have been Axon and Michelle Cochran and these other entities. They want to engage in business. They say, no, this is antitrust. So it's impinging upon what they say is a right. Well, if you do that, what's the mechanism by which you can impinge on that or impinge on a privilege? The MVD will often delegate these decisions to an administrative law judge. So for example, if you get a DUI case, you have two things that happen. You have a criminal proceeding and you have an administrative proceeding, which really goes to the validity of your license. One goes to the criminal or innocence. One has penalties about putting you in jail, penalizing you monetarily. The other has to do with your driver's license. So if they're impinging upon that, those decisions, the non-criminal decisions, will often go to ALJs, administrative law judges, and they've got some base level authority. Here, as prescribed by statute, a party objecting to the proceedings makes its claim first within the commission, and then if needed, to the Federal Court of Appeals. But the parties here sidestepped that review scheme and brought their claims in district court, seeking to enjoin the administrative proceedings. Cochran and Axon asserted that the tenure protections of the agency's ALJs render them insufficiently accountable to the president in violation of the separation of powers, saying these judges in these agencies that we go through, they're bureaucratic nightmares, and they don't allow us to actually bring our claims. They don't respond to the executive agency, meaning they're not reportable to the president. Axon also attacked as unconstitutional the combination of prosecutorial and adjudicatory functions, saying they're kind of like investigating us for criminal investigations, and they're also adjudicating some licensing things. It's too much power embodied in one agency. Each suit premised jurisdiction on the district court's ordinary federal question authority. The suits initially met the same fate: dismissal, lack of jurisdiction. The district court in Cochran's case held a review scheme specified in the SEA, the Securities Exchange Act, gave them permission and superseded other challenges, including Cochran's. Similarly, in the other case, they found the same way. Ninth Circuit Court affirmed that. They said, hey, the statute says you have to make your remedy, you have to go this way, and if you don't, if you think you have another constitutional objection or something, the statute overweighs that. And the Court of Appeals confirmed, saying that the district court's dismissal of the constitutional proceedings, saying, yeah, this falls right within the act and you can't bring claims outside of the act. In this case, the court held the statutory review schemes set out by the SEA and the FTC do not displace a district court's federal question jurisdiction over claims challenging as unconstitutional the structure or existence of the FTC or SEC. In other words, the act was trying to substitute essentially their ALJs, their law judges, for a bunch of proceedings and supplant the federal courts, saying we're going to insert our judges in place of your judges, and our judges will resolve these, and you don't get to resolve them. And what the lower level judges were doing in the actual court of law, not the ALJs, they were hearing these claims and they were saying, yeah, we don't have the right to hear these claims. You don't have jurisdiction to sue us here. You have to go through the administrative state. You have to go through the FTC or the SEC. And they're saying, no, we don't. We can file directly in court. And the lower court said, no, you can't. You got to go back through the administrative act. And the Supreme Court said, no, what are you, nuts? You can come back through the courts because you can't replace our courts with your ALJs. Although district courts may ordinarily hear challenges to federal agency actions by way of this jurisdiction, agency adjudications are generally ill-suited to address the structural constitutional challenges like those maintained here. The court concludes that the claims here are not the type the statutory review scheme at issue reach. So reverse and remanded back down to the lower level courts to hear the claims, which is good news. And I think that is the right call. This is a separation of powers issue. You want to make sure that the legislative branch does not create executive agencies that give the executive agencies the full power of the courts, which is essentially what they were trying to do here. And the Supreme Court said, no, not going to do that. Some of those claims might be appropriate to go through those agencies, but not the types of claims that are being brought here. They're challenging more constitutional underpinnings, and those underpinnings are legitimately brought in court. So a good outcome. It is not close, right? This was 9-0. This really, I think the consequence of this is the courts just reaffirming their sovereignty as the courts. These executive agencies can't commandeer some of their authority through their agencies, which is very good news.